What happens if the judge refuses to allow your expert to testify in your medical malpractice case? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. Well, what will happen is that you'll wind up having your case dismissed. It is critical in a medical malpractice case that we bring in a medical expert to support and confirm each of the claims that you're making in a medical malpractice case. If, for whatever reason, the judge refuses to allow our expert to testify, then we have no way to prove our case. Now, here's what will typically happen. Your Honor, at this time I call Dr. Jones to the witness stand. Objection, the defense yells. The judge asks the defense attorney, what's the objection? Your Honor, Mr. Oginski has failed to notify us in a timely fashion of who his expert is and what his expert will be testifying about. And as a result of that, we've not had an opportunity to prepare cross-examination. Mr. Oginski, what do you have to say? Your Honor, I hired this expert at the last minute only because I couldn't locate and identify an expert who was going to be able to come in and support the testimony. Now that we retained an expert, I immediately notified the defense attorney, and as you know, we're not required to identify the expert by name, but we did provide him with all of the witness's credentials as well as what the expert's going to be testifying about. Defense counsel, what do you have to say? And now the defense attorney is going to have to give another explanation why he's prejudiced for getting this information at a late date. And the judge has a number of options available. He can either allow the witness to testify without any other issue. He can preclude, meaning prevent the expert from testifying, which means our case is out the window and we can no longer prove your case. Or the judge might fashion a remedy in between those two things. He may say, Mr. Oginski, you can put your expert on, but you may be fined because you delayed in notifying the defense, and I might have to pay a fine to the defense attorneys as a result of that. So the bottom line is, if the judge decides not to allow the expert to testify, that's it. The case is over and finished. We cannot prove your case. And that's something we never want to happen. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case during the course of the litigation. You know, I realize in all likelihood you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do if you have legal questions is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.